Welcome and thank you for attending. Questions can be asked using the questions pane in the webinar control panel. A copy of the handout will be distributed later. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Good afternoon, SHRM Long Island. This is Henry Shapiro from our Jackson Lewis Long Island Melville office. I hope everybody is having a wonderful day, some sun, and getting ready for the weekend. For those of you who were to be attending this past Wednesday, our SHRM dinner meeting update, we apologize. Obviously, it was canceled due to the weather. Hopefully, everybody got home safe without any issue. But we're going to cover part of what we were going to discuss there. Obviously, we're in a much more reduced time frame where I want to get through everything in today's slides. But what we want to talk about today is what's coming up this year and what we can look even further down the turnpike for to come up in 2020 based on what has initially come out from Governor Cuomo's fiscal year 2020 budget. It's, as you can imagine, a lot that's going to possibly change your HR professional day-to-day life. Some of it not so important, more kind of, deterrence towards employers for committing violations. But what we want to make sure we pay attention to are the issues that will change handbook policies, the issues that will change how we run our day-to-day operations. So let's get through that. So what's new? New York State Legislature, as we just said, they convened on January 9th, so about 6 weeks ago. To the difference this time, as in years past, for those of you who have been doing this for more than 10 years, what I'm going to tell you is something that you may have been accustomed to earlier in this millennium. But for the first time in 10 years, we have an all-Democratic New York State government up in Albany. Why does that matter? Why does that matter? And you can probably guess the answer. New York, California East, as some people call it, is now equipped to take a much different approach with government and legislation than what we see down in Washington, D.C. with a Republican administration, at least in the executive branch with President Trump. There is going to be an easier time for Governor Cuomo to push through his agenda, which means what we expect to see is New York City type regulations and New York City type laws pushed out across the state. We've seen it in some localities that are largely Democratic controlled, obviously with Mayor de Blasio in New York City. Obviously, we have some similar legislation we've seen in Westchester. They've adopted a paid sick leave. A salary history ban is going to be coming out. So some of the things we've already seen in New York City is slowly starting to extend its tentacles throughout New York State. Now with an all-Democratic government, what we really anticipate are seeing statewide changes. And why does that matter? Because obviously now this is going to affect all of you lovely employers in Nassau and Suffolk. Even Suffolk we have seen with the salary history ban coming up in this June, taking some of New York City's ideas when it comes to progressive, employee-friendly legislation. So one of the first things that is going to enter your workplace, and you might not see it on a day-to-day basis, but it's absolutely something that is becoming more prevalent in society and more prevalent in this country. Starting in a couple of days, so it goes into effect on Sunday, Governor Cuomo signed the Gender Expression Non-Discrimination Act. So you could pull the first letter of each word, and we've got GENDA or GENDA, however you want to call it. But the Gender Expression Non-Discrimination Act, what does it do? So essentially we are kind of adding a protected category. It prohibits discrimination based on gender identity or expression and includes such offenses under the hate crime statute. This has already been the position of the New York State Division of Human Rights. This has not been added to the law yet. This will be added to the law in a couple of days. As you can imagine, it passed without much hesitation. What is gender identity or expression? So what you cannot discriminate based on, and I have to believe many people we're not discriminating for any reason, let alone based on gender identity or expression, but just another protected category, so to speak, to add to your list is a person's actual or perceived gender-related identity, appearance, behavior, expression, or other gender-based characteristic, regardless of the sex assigned to that person at birth, including but not limited to the status of being transgender. So beyond just transgender people, it's a rather broad definition, as you can see. It's actual or perceived. So the perceived word is key. We see that in the Americans with Disabilities Act, whether someone is perceived or regarded as having a disability. Here, it's the employer or the supervisor or the manager's possible perception could be considered unlawful. So, just a word of advice that we all know and hear day in and day out. We always want to make sure any decision we are ever making is obviously never based on a protected category. Every decision should be for a legitimate business reason, whatever reason that may be. You might want to consider conferring with counsel before you make some kind of decision, especially a termination, but that it's always done for a legitimate business reason, never based on an unlawful act or an unlawful protected category, and that we are consistent in our approach and that we document our approach. We always want to make sure we are not applying our policies or our rules and regulations of the workplace differently across different bodies of employees, across different departments, and we never want there to be a distinction based on a protected category, because if so, there's potential exposure. Discrimination based on a reproductive health decision. So both houses of the state legislature, this one's a little bit different than GENDA we'll go with. GENDA is going into effect in a couple of days. This discrimination based on reproductive health decision has not been signed yet by the governor. It has not gone to him yet. I forecast no reason why Governor Cuomo would not sign it. But what is this? This legislation creates a civil cause of action against employers alleged to violate the law, requires employers to include remedies provided under the law in their handbooks and prescribe remedies, including liquidated damages, which could be double damages, 100% double. For relief. And what would it be for? If you, as an employer, discriminate based on an employee's or an employee dependent's reproductive health decisions. So again, it is a very broad definition. Reproductive health decisions. There's not much more guidance out there on this just yet. It is something that likely, if it is signed into law by Governor Cuomo, we'll get a little bit more information on, I would anticipate. But if not, which would not be too unsurprising with New York State, we need to understand that a reproductive health decision right now is you should construe it and interpret it broadly until we hear otherwise. Again, not something that I anticipate people coming across day to day. It doesn't smack you in your face as clearly as possibly age or race or disability or gender, but it is something that you're going to want to update your handbook policies if you have a policy that specifically itemizes the protected categories, something you want to educate anybody that's in a decision-making position to be aware of. But again, this should not be, it is something that we are just going to want to make sure that no one is basing any decisions, no one is making any unwelcome or inappropriate comments. Even if this law isn't passed, these things shouldn't be occurring, period. But in the event that this law is passed, it could actually then become a civil action. So looking forward for those two, the GENDA and the reproductive health discrimination, those are coming. The reproductive health one is close. It's got to be signed by Governor Cuomo. But for looking out, and now we are casting our fishing reel way, way out. This is for fiscal year 2020. The New York State Executive Budget Proposal, many ideas that would affect everybody on this call. In the days and weeks ahead, we're going to probably get some determination by April 1st of what we will more concretely expect to see in the budget and what makes its way in and what is cut and possibly tabled for another year. Again, all Democratic government up in Albany, more likely than not, that progressive type agendas are going to get in, which usually lead to employee-friendly legislation, employee-friendly laws. a lot of what we see here, as I said earlier, comes from New York City. And it is not, Governor Cuomo is not going to be giving out any credit to Mayor de Blasio, but it's more so that Governor Cuomo's agenda, budget, and initiative are things that have already gone through in New York City. Equal pay and salary history ban. So the salary history ban I was alluding to a little bit earlier, this would actually propose amending the human rights law to prohibit employers from inquiring about salary history or using salary history information as a factor in determining whether to offer employment to an individual. This is something that if you're in New York City, you're already living with this. You took off your applications. You took off all questions about how much people used to make in an old job, because the thought process being that information would then maybe make you underpay somebody because they were underpaid in a past place of employment, and all you are doing is belaboring what an issue that should be cured. This is also something that we see in Westchester County. It's something that we are going to see in Suffolk. I think I spoke on this issue a couple months ago to all of you. This is something that's going to be coming in Suffolk in a couple of months, I should say. Nothing yet in Nassau. However, the New York State human rights law change would obviously affect Nassau. And you are still allowed to ask an applicant his or her salary expectations. What you cannot do is ask them, ask them about their salary history, because ultimately maybe that's coloring your opinion as to why you are paying them what you are paying them. They are looking to get out of that and move in a different direction. That this would do it. It would also further this proposal would also further amend the labor law to require that members of a protected class, and we all know how many protected classes are covered under New York State already. Not as many as New York City, but much more than the federal government covers under Title VII and the ADA and ADEA and so on. But members of a protected class would be required to receive equal pay for equal work in public and private sectors. This really shouldn't be anything new. For those of you who work with Jackson Lewis, this is a big focus of our affirmative action group. The equal pay for equal work is obviously an initiative that we have all probably heard in the media. Especially it stems a lot from the Hollywood line of employment, where female actresses are paid less purportedly than male actresses, and statistics do back it up. And it did have a lot to go into the Suffolk legislation for the salary history ban, that they are looking to get rid of these old school processes where women or people of other protected categories, maybe African Americans, have been paid historically less than their either Caucasian counterpart, male counterpart. That's what this is looking to change. Workplace harassment protection. So the first one is a really big one for all of you that we really all want to keep an eye on and see if this makes it into the budget. The proposal is to make a harassment claim easier for an employee. How? Because and when I say claim, I'm talking about a legal claim. Under your policy is likely going to be more protective than the law. So we never even teeter on the balance of getting to something unlawful. Here, under the law, if Governor Cuomo's proposal were to get through and be signed into law, it would eliminate the severe, right now, the way it's written, it would eliminate the severe or pervasive requirement for harassment. And again, harassment, we all talk about it in the nature of sexual harassment. It is harassment based on any protected category is unlawful: race, gender, disability, age, you name it. The severe pervasive element, I will tell you, is often how you can, and when you are defending against a claim of harassment in front of the EEOC or the State Division of Human Rights, you're often able to distinguish whatever occurred as maybe an isolated stray remark or an isolated incident. It is not usually you're able to get around your defenses built upon it not being severe or pervasive. With that gone, all it needs to be is unwelcome, and then offensive, physical, verbal, visual conduct that would be considered as such by the reasonable person, which that standard is always, somewhat gray. But this would be a lot easier to prove if unwelcome and offensive are the main element, and being based on a protected category are the main elements. Taking out the severe or pervasive would vastly change the harassment landscape. As you can see, the standard, which tracks the New York City human rights law, would expand the scope of potential harassment claims greatly. The proposal also would amend the general obligations law to mandate that all pre-dispute non-disclosure provisions in an employment agreement allow the filing of a civil complaint. So this is more a nuanced area that you probably won't see too often, depending on how often in your workplace you deal with employment agreements. It would also require employers to conspicuously post a sexual harassment educational poster in the workplace. There's nothing surprising about that. New York State loves its posters, loves its handbook requirements, loves its training requirements. So a poster on sexual harassment education is nothing to be too surprised about. Protection of breastfeeding in the workplace. This is, again, something that we have seen somewhat in New York City. And for those of you who attended the webinar that Craig Roberts and I presented, this is something where we have seen the lactation room requirement in New York City going into effect in just under a month. The proposal in Governor Cuomo's budget includes a provision that would guarantee breastfeeding rights in the workplace and protect those rights under the human rights law. It would also require this to be a reasonable accommodation area as well, similar to obviously disability and religion, to the extent we need to make reasonable accommodations. Breastfeeding is going to be one. There's no specific language right now about lactation rooms being required on a state level, but it would not surprise, I think, any attorney that deals in this land of labor and employment law if a lactation room requirement became something floated about up in Albany to apply statewide. Obviously, New York City has already enacted expansive legislation in this regard. Wage theft, this one we can gloss over rather quickly. Criminal penalties could be increased for employers who actually try to knowingly engage in wage theft. Obviously, the knowing is always a key element. Proving intent is not easy, but in New York State, they want to make it even more of a penalty for those employers that do it. I have to imagine that this will not impact many people on this call, if any, so I don't want to spend too much time on it. But if when you get a copy of the slides, you want to take a look at what the penalties are going up to. Hopefully no one's ever faced these penalties, but they are looking to make it easier for it to be a felony rather than a misdemeanor for employers who violate 198A of the labor law, which has to deal with knowingly withholding wages or not paying proper wages, leading to the employee to not receive the proper pay for the hours he or she worked. So I titled this a newly proposed sexual harassment package because that's kind of how it was introduced. However, it's a little bit more far-reaching. So again, these are all proposals in the budget. These have not been signed into law yet. These are not active yet. But one piece of legislation require employers to inform employees that non-disclosure and non-disparagement provisions in employment contracts cannot prevent employees from speaking with law enforcement, DEOC, New York State Division of Human Rights. Many release agreements that Jackson Lewis prepares. There's usually a carve out in there to allow people to still participate in these kind of investigations. You don't want to, so some of you might already be ready for this. You might have to do some slight tweaks, but this is something that we have looked at in the past. Another piece of legislation would amend, this is a big one, would amend the human rights law to extend the filing period for a complaint with the Division of Human Rights from 1 year to 3 years after the alleged unlawful discrimination practice. So that's for any protected category covered by the state human rights law. Would possibly give you extra time, an extra 2 years on top of what it already gives. So that is a big one because it's something where you can't officially rule something out just because now a year has passed since the possible action. Now, if it goes to 3 years, that's obviously tripling it. That's a big leap. It would also toll the statute of limitations during ongoing proceedings from the earlier of the commencement of an investigation or the filing of a complaint to the conclusion of an investigation. So now the employee, I should say, making a complaint in the workplace can help them with the statute of limitations. So it's, if this gets publicity, it is going to encourage employees to file complaints sooner rather than later because they're buying themselves some time. They're tolling the statute of limitations. And then lastly, I just want to get to this one. required vacation time, for those of you that heard, and whether or not you're in New York City, this is something you should pay attention to. So Mayor de Blasio has indicated that he will propose a law that requires at least 2 weeks of paid vacation. Now, many of you on this call might already give paid vacation. Many of you might only give a week, depending on your industry. If this goes through, it will be the first law in the country regarding paid vacation time. The initial feedback is it's going to track the New York City Earned Sick and Safe Time law and apply to New York City businesses with 5 or more employees, which is similar to the Sick and Safe Time law. It would not apply to independent contractors. So that's all well and good. But paid vacation time, if we just wrap this into everything else that, why does this matter to you? If we wrap this into everything else that has gone on in New York City that might then extend out statewide if Governor Cuomo gets a hold of it, you've got the paid family leave law, you've got the New York City Earned Sick and Safe Time law. There are several laws coming out that guarantee or require you to provide paid time off that it might be time every year that passes to reevaluate your policies and reevaluate what you give to your employees as far as benefits and paid time off benefits, because you're going to probably need to reword policies to make sure either A, employees don't double dip, or B, you might realize you need to start pulling back some of your voluntary policies, as there's enough laws out there right now that cover all of these, paid benefits. So if you want to have employees in the workplace, maybe you start drawing back on your voluntary policies as the law starts to require you to offer other paid benefits. So again, that's something that could be coming in New York City. I anticipate that it will. It is not far enough along yet to tell you when it would take effect, but it's just something to keep an eye on. So for all of you that were patient enough to stay on this, I appreciate it. Thank you. Have a wonderful weekend, and we look forward to speaking with you in March. Take care.